Lords, my lady. I was dealing with my third point that is relevant to what we have to say about mutuality, and I was about to turn to the contention that is made against us, that the present case is no more than a contract that in effect can be terminated at will by either side and without sanction, but that, it is said, is irrelevant, since what matters is either the existence of the contract or its non-existence. Now, we accept, of course, that whilst the contract is in place, the nature of its obligations must be tested, and that there is nothing to test once the contract is terminated. So we accept that. But we say that rather misses the point. What matters is that whilst the contract is in place, such that there has been offer of an engagement and acceptance, but before performance, the fact that it can be ended by either side without sanction is a relevant aspect of the nature of the mutual obligations owed by the parties, in that it reveals them to be particularly flimsy, and specifically it tells us something that must be regarded as being relevant to the inquiry, where that inquiry is on the authorities into the nature of the obligations owed by the parties. Now, there are references in the authorities. A case called Byrne Brothers, was Mr. Recorder Underhill as he was then, paragraph 26 at page 471 of the bundle, and Mr. Justice Elias in Delphi Diesel at paragraphs 13 and 30, pages 475 and 478 of the bundle, to the effect that the ability to terminate a contract simply means that once that right is exercised by one or both of the parties, there is no contract in existence to which the mutuality concept might apply. And what is said in those authorities is right, with respect, it's obvious, we have no difficulty with it. But that does not amount to a conclusion that the right to terminate is not relevant. Now, the way the point was put in the Court of Appeal, in this case, put by the Court of Appeal at paragraph 68, key documents, page 100, that somehow the right to terminate does not negate mutuality.
Paragraph
100. Paragraph 68, page 100. So it was said, a distinct legal issue in this appeal is whether a provision in the contract which enables one side or another to terminate
I think you gave us a page in the key documents bundle, but I think we're working on the main bundle.
Page 68 in the main bundle is 149, I'm obliged. So the way it was put in the Court of Appeal by Her Ladyship was whether a provision in a contract which enables one side or another to terminate particular performance negates the mutuality of obligation, which is one of the necessary elements of a contract of employment. Now, it was not our case below, nor was it the approach of the first tier, that the existence of such a right or ability to terminate negated mutuality of obligation. So we did not, nor do we say, that it is determinative, destructive of mutuality of obligation. We do say it is a relevant factor to be weighed when determining and addressing the nature of the obligations that are owed by the parties.
So it makes the obligation a bit less mutual? This is sort of this is your degree thing, is it?
It makes the obligations owed by the parties particularly flimsy, yes.
And this is weighed in at the first stage of the...
Well, I want to come back to where it's weighed in a second.
Okay.
But
Yes, there is a mutual obligation, but you say it's not a strong one, because there may be many contracts where either side can terminate at will, but what you say is here it's been terminated before any performance.
and that freedom is in both parties.
Yes.
But is that different from a sort of Carlisle and Carbolic Smoke Company type contract? If you go and referee this match, we will pay you.
With the rider that the person making that offer
Can withdraw it
Can
at any
withdraw it
time
at any
before the
time.
person starts inhaling
I think, yeah, they probably accept an obligation before they turn up on the pitch. It's not just by refereeing that they accept.
Yes,
It's not a
that's
unilateral
true.
contract.
it's not a unilateral contract. But the nature of the arrangement for a particular game to referee Tranmere Rovers versus Cambridge United on Friday evening is PGMOL say, we would like you to do this unless we change our mind. And the referee says, I agree to do it unless I change my mind.
But if those are contractual obligations, which I think you accept, like I can see there could be a case where it's too vague to amount to an obligation. But if it is an obligation, then I cannot see why the fact it's capable of being terminated at will should make it less likely to be an employment contract. It seems to be heading towards an argument that the most vulnerable kind of employee whose employment can be terminated at will might not turn out to be an employee at all, so he's got even less rights.
Lord, that's not my case. My case is, or what was said against us in the Court of Appeal judgment is that somehow it negates mutuality, and that was never my argument, nor is it what the first tier said. Case against me now, in effect, is the ability of either side, the freedom of either side, not to see the contract through is irrelevant. My case is no, it is relevant but not determinative. Now, does that lead to the conclusion that a putative employer could say to a vulnerable group of would-be employees that we can avoid all of the consequences of this being a contract of employment by making it terminable at will? The answer is no, because it doesn't negate mutuality.
But just to address the question of what stage it comes in, you're saying mutuality is a necessary condition. So does this go in at that point, and could it result in there not being mutuality that makes it capable of being a contract of employment? Or are you saying it doesn't come in there, it won't affect that question of whether you've passed the necessary condition, but it comes in again at the end as part of an overall assessment? How does it work?
My primary case, my Lord, is it comes in at the first element. But if that is not right, then it at least comes in at the third element, because my Lord Richards was right in Appelhouse to say, even at that third stage, mutuality and control can be examined as relevant factors to be weighed in the balance at that third stage. Now, assuming my Lord is right, and we say with respect that he is, it doesn't matter greatly to my case in this appeal whether it comes in at the first stage or at the third stage, as long as it comes in somewhere, But in answer to your Lordship's question of principle, we say it ought to come in at the first stage, but if that's not right, it does come in at the third. And that was my fourth of my 5 points.
And how do you decide at the first stage whether the terminability of the contract prevents it being treated as sufficiently mutual, or doesn't prevent it from being so treated?
Because whatever legal test this court lays down as a result of this decision or later decisions, there will have to be some room within a framework for a fact-finding tribunal, whether the first-tier tax tribunal or the employment tribunal, to weigh the significance of factors against a particular fact pattern.
Well, then replace my question with the first-tier tribunal when I say how does one decide. How does the first-tier tribunal decide whether the fact that the contract is terminable by either party means it isn't mutual enough or it is? Do they just stick a finger in the air?
Well, my Lord, no.
Well, what is the question they're asking themselves then?
Well, on the current state of the authorities, before this court has addressed the answer to this particular appeal, you're told as the first-tier tribunal to look to the nature of the obligations. That means understanding the nature and significance and degree of the obligations owed in either direction. And you are told to form a view about the sufficiency of the mutuality. Now, in that...
I still haven't understood how the existence of an obligation is a matter of degree.
Well, the existence of an obligation, in one sense, is not a matter of degree. But the nature of that obligation requires the tribunal, any tribunal, to form a view about the strength, the significance of a particular obligation. Now, here, it's against the background of an umbrella contract, which itself has no mutual obligation in it. But what the first tier found, this is not disputed now, is that even in a single engagement to do a particular match, either side can decide not to carry that engagement through without sanction. So you have no relevant mutuality in the overarching agreement. The ability of either side to withdraw without sanction from the individual engagement. And we say those facts are relevant material in weighing the significance of the obligations owed by either side in forming a view about this notion of mutuality.
It's very easy if you just put it into the third category, thirdly.
What?
You avoid all these questions and it becomes straightforward.
Well, I'm not sure one avoids all of the questions my Lord has put to me.
You make an assessment as to the nature of the obligations that exist. And so you have the irreducible minimum at the first limb, and you have, and the third limb, you then take into account the flimsy nature of this obligation. Well, what's wrong with that conceptually?
My Lord, nothing.
Yeah.
The difficulty I have with the third stage, and now you say the first stage, is that when you're talking about whether this feature is consistent or inconsistent with it being a contract of employment, it's as if you are comparing it with something, but the thing you're comparing it with is what you're trying to define. It's as if there is something else which is a contract of employment that you are comparing this with. But this is the exercise is to discover whether it is.
Right.
But is the exercise that you look at a kind of paradigm contract of employment at one end of the spectrum, and you look at a paradigm barrister client, decorator painting my kitchen type engagement at the other end, and you look at where this is and decide where you put the borderline and whether which side it falls on, or it is the comparison that's inherent in asking the question, is this feature consistent or inconsistent with it being a contract of employment? Is that comparator something else, which I don't quite understand what it is?
2 points, my lady. We would absolutely accept and endorse the proposition that where the older authorities talked about the third stage being a question of inconsistency with some prima facie view that it is a contract of employment, you're rather begging the question to be tested. And the authorities conceptually just didn't work terribly well. So we would accept and endorse that. Your Ladyship's second proposition that there is, in practice, a spectrum between someone who's engaged, let's say, to be a receptionist in an office 5 days a week, 40 hours. No one may come into that office for an entire week, but that receptionist, he or she, is paid for being there. They may not actually do anything apart from turn up and sit there. It's relatively easy to come to the conclusion that that's a contract of employment. The other end might be my fruit picker, or my decorator, or me as a barrister. I am given a project that might just be a few hours long, or it might be a day long, and you can say, well, there you are, if you're a fruit picker, if you turn up and you're selected and you work, we will pay you for the hours you work or for the weight of the fruit you pick. Now, the facts of this particular case are somewhere in the middle. But
it is what I've described. Do you accept that that is the nature of the exercise that is being carried out?
It is, my lady, yes. And the debate that I've had with the court this morning really is what is the framework of principle against which that spectrum is tested.
I can well understand how the fact that there's no, for example, no overarching contract of employment, the fact that each part can back out, that's all relevant, rather like in the Windle case of the interpreters, when you get to considering, well, is this a relationship of subordination and one in which there's the relevant control? But I struggle to see how mutuality is itself a matter of degree or weight. It isn't simply introducing confusion into what's already a difficult enough area of the law.
Well, if for a moment I accept your Lordship's observation and say, let's assume it doesn't fit at the first stage or first element of ready mix, from my Lord Stephen's point that, well, it would be a fact to be weighed at the third element. Even at that third element, one is required to ask oneself the same sort of questions. What is the nature and strength of these obligations? And the fifth point, which I will come to in a second, but my Lord alluded to it, is that it is significant when judging the nature of the obligations in an individual engagement to bear in mind that the overarching umbrella contract does not have relevant mutuality. And that is said in the Windle case and was confirmed by my Lord in Uber, paragraph 91 at page 782.
Yeah, but that's looking at the question of, as I say, subordination and control, which in a number of cases is treated as really what the essential thing differentiates employment from self-employment.
Perhaps, my Lord, can we just take up Windle, which is page 648 of the bundle. paragraph 23. And the way my Lord Justice Underhill puts it is there in terms of the mutuality in the umbrella agreement, casting light on the status of the individual engagement.
But the way in which it does so, I think what he says there bears out what I just said. May tend to indicate a degree of independence or lack of subordination in the relationship.
Well, I'm not quibbling with the way it appears on the page, but my Lord, I don't read that as being exclusively about control. It's talking there in terms of mutuality of obligation. Now, wary of telling my Lord what my Lord meant in Uber, but if we perhaps turn up paragraph 91 in Uber, page 782 of the bundle.
Dangerous will probably point out I said the opposite there.
But I'm hoping I will find that you did. But paragraph 91, page 782. Your Lordship cites from Windle at the end of that paragraph, but the earlier parts of that paragraph where there are citations from McMeechan and Prater and James and Redcats are in terms of mutuality of obligation. So standing back just for a moment, my point, I'm sure the court has it here, is that the nature of the obligations owed in this case are material. And for my part, for a reason I'll show you in a moment, it doesn't matter much whether they're in the first element or the third element. But even if they're in the third element, one has to ask the same questions by examining the nature of the obligations. And my last point under this heading is just to make clear what I think is apparent anyway, that the worker test here, for that middle category in the employment protection world, is a statutory test that looks to the obligations on the putative worker. And that can be seen in section 233 of the Employment Rights Act, which is at page 256 of the bundle. So there are two categories. Lim A, you're a worker if you're under a contract of employment, that's a common law employee. And then Lim B, any other contract, express or implied, and if expressed, whether oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party whose status is not by virtue of the contract a client or customer. So the feature that makes you a worker is the type of obligation on the putative worker.
So far as the domestic law is concerned.
Yes. But there is no requirement that there be any type of obligation on the putative employer. So one of the, if not the key difference between someone who is a Lim A common law employee and a Lim B statutory worker is that in the former case, there is some type of obligation on the putative employer. And if this court were to decide that the common law test for employment merely requires of the putative employer that he or she will pay for work done, there is then no relevant difference between a common law employee and a Lim B worker.
I can't accept that, because cases like the Byrne case, Mr. Recorder Underhill says that the central difference is one of degree of control and subordination.
There's a lower pass mark,
Yeah.
he puts it. But each of the relevant tests would then have an element of control and an exploration of the degree to which your counterparty is a client or customer of a business of your own. And this was, in effect, the debate that was recently had in the Court of Appeal in the nursing midwifery case, Somerville. And this is in the bundle at page 794, in particular paragraphs 45 and 52, which are pages 805 and 810. What was said in that case was that even in the statutory worker test, there must be imported an obligation on the putative employer to provide work or pay in lieu. And the Court of Appeal said, rightly in our submission, no, that's not right. It's not part of the statutory worker test. And indeed, that is one of the key things that draws a distinction between the statutory worker test and the common law notion of employment. And indeed, that divide explains in part the outcome in both Pimlico Plumbers and in Autocleanse, because the particular individuals there were found to be workers, but not common law employees because of the absence of the relevant notion of mutuality. So whatever notion of mutuality this court arrives at has to reflect and respect the divide that Parliament has drawn between a common law employee and a Lim B worker. Now that's what we say as a matter of principle, unless I can help the court further. That would, unless there is anything else, take me to my fourth heading, which is the decisions below on mutuality. And here, can I invite you to turn up the first tier decision? If you're working in the main bundle, it begins at page 202. In the key documents bundle, it begins at page 153. I don't know which is the most convenient reference to the court.
Probably is.
Probably both of them, yes. Well, I'll try and do both as we go along. What I would like to do quickly is just turn the paragraphs, and maybe that's easier. So beginning either at page 153 of the key documents or 202 of the bundle, and the court will well have in mind the need eventually to read all of this carefully, but paragraph 14, the first tier, starts with ready mixed concrete. Paragraph 15 recognises that an individual contract might be a contract of employment. Paragraph 17, written without the benefit of my lord in Athol House, describes the third condition of RMC as a negative one. My lord has said, well, that's not quite right. So with that qualification, there's recognition there of the three elements of ready mix. Paragraph 18 recognises that the authorities have contemplated other approaches. But as we'll see, the first tier doesn't think they're separate tests that lead to a different answer. Paragraph 19 onwards addresses the evidence and the findings of fact. Paragraph 32 that sets out how MOAS works. And then paragraph 50, main bundle, page 213, key documents, page 164. The tribunal makes findings about the referees and their pursuit of a very serious hobby. And then paragraphs 51 and 52 deal with how the MOAS system works in practice, and the freedom of either side, in effect, to change their minds. And then turning on a few pages to paragraph 103, so main bundle, page 225. Key documents, page 176. That records the evidence about the ability of the referees and indeed PGMOL to change their mind. And then paragraph 104 is an important paragraph because this is the evaluation by the first tier of the findings of fact they've made. So they identify the general picture that emerges. So 104 is important. And just pausing there, there's no Edwards and Bairstow challenge to any of these findings of fact. And then turning on to paragraph 118, 229 in the main bundle, 180 in the key documents bundle. These are the submissions made by my learned friend. The revenues case was the individual engagements to officiate at matches were contracts of employment. And then the tribunal discusses its answer beginning at paragraph 124. The first part of its decision was whether there was a contract at all. And it concludes that yes, there was, and that was not pursued on appeal. And then from paragraph 135 onwards, it deals with the terms of the overarching contract. So it identifies the terms and then scrutinises them in paragraphs 141 and 144 onwards. So it's alive to all of the terms of the overarching contracts. It correctly reminds itself at paragraph 152, the point in Windle that we've just talked about. So the nature of the umbrella contract can throw light upon the classification of the individual engagements. And then from 159 onwards, the tribunal addresses the notion of mutuality in the context of the individual engagements. Paragraph 159 is important. The tribunal finds that there is a contract. There is no sanction on either side for either party changing its mind once the game has been offered and accepted, then in 159, the tribunal finds at the end, subject to these points, during the actual engagement, there would be some level of mutuality. Paragraph 160 deals with a point about Weight Watchers. Then 161, they say, however, although not on all fours with the fact of Weight Watchers, it is in our view relevant that the discrete contract started when an individual match point was offered and accepted, that even after acceptance the referee had the ability to withdraw from the engagement before he arrived at the ground, that PGML was also able to cancel. So the tribunal say it's relevant. They don't say it's determinative. They do not say it negates mutuality. They then go on to contrast that case with Weight Watchers and Cornwall County Council at the end of 162. In this case, there's no comparable obligation outside the actual performance of duties at a match. They then deal with control, which I'll come back to. But 165 is relevant even on mutuality because they're alive to the fact that some of the terms of the umbrella or overarching contract are relevant in determining the status of the individual contracts. So they say some of these obligations applied to match day activity, most obviously the match day procedures, and were therefore relevant to individual match appointments. So they're alive to the fact that some of those terms are relevant. And
That's a rather different thing, though, to say, obviously it is going to be relevant to control if they apply during, in relation to the matches. It doesn't help your submission on mutuality.
Well, all I'm establishing at the moment is that they were alive to the fact that some of these terms of this contract can be relevant to this one. Their conclusion at 170 is to look at what they call the third condition and other approaches. They hark back to ready-mix concrete. They then say in 171 we've considered the various other tests of employment status referred to, so Hall and Lorimer. And then they look at some of these relevant factors in 172 and 173 onwards. Their conclusion is at 174, standing back, this is their evaluative exercise, our conclusion is that there was insufficient mutuality of obligation. Now, for our part, they made the relevant findings of fact, matter for them. They evaluated those findings of fact, a matter for them. They were alive to the relevant authorities and the relevant legal principles. And they have applied those relevant legal principles to the facts found and weighed by them. And specifically, they say, yes, there's some mutuality because there was offer and acceptance, but either side is entitled, in effect, to change their minds. And standing back and weighing that alongside all the other factors they identify, their conclusion is there was insufficient mutuality of obligation. And that, we say, is a perfectly appropriate exercise for a fact-finding tribunal to undertake, and not one that admits of an error of law. So what then did the upper tribunal say?
And would you say if they were wrong in characterising their conclusion as insufficiency of mutuality of obligation, and perhaps what they should have said is our conclusion is that looking at all three elements in ready-mix concrete, we don't think it amounts to employment, that they would effectively be saying the same thing, and then there could be no possible suggestion that they had misapplied the principle.
Well, that in effect is what they're doing in 174, because I only read you part of that sentence because they also express a view overall about control, and they have clearly in 172 and 173 that I skipped over, they've weighed up all sorts of other factors. So the exercise they're doing in 174 is the third element, third stage evaluation. At the moment, I'm only concentrating on what they said about mutuality.
I mean, I was puzzling a bit about that, whether that is what they're doing in 174. It seemed to me they were majoring on insufficient mutuality and control, and didn't regard the factors that might point to a contract of employment taken into account in Limb 3 as displacing their conclusion of an insufficient level of control and mutuality.
Well, I don't with respect, think that's what they are doing,
right?
Because they're alive to their earlier conclusion that there's some element of mutuality.
Right. They say it's insufficient.
And in 170, they record their conclusion that there's some element of control. But what they then do in 171 and 172 and 173 is to look at all of the other factors. And their conclusion in 174 is not expressed in terms of some presumptive view for which there is no countervailing balance. It is a standing back evaluative conclusion. And point this course has no doubt heard many times, but one does have to read the whole decision to see all of the factors and all of their reasoning. It's very dangerous in this court just to read a few lines here and there. Eventually, one has to read the whole thing.
Well, as you know, before you come into court, we will have read the judgments below.
I know.
But when we go back to 159, the mutuality that they found is simply the Saturday afternoon mutuality. It's once the referee was at the stadium and was getting paid for it. Because they distinguish between the appointment and the engagement, the latter being the performance at the match.
Yes. And to reiterate, this was not a tribunal who didn't know that the individual engagements could be contracts of employment, because they say as much in paragraph 15.
Again, you use the word engagements, the individual appointments for a particular match, yes.
So you say they didn't fall into the trap of thinking because this is only an individual contract and not an overarching contract, it can't be a contract of employment. They didn't fall into the trap of saying, well, because we found that the overarching contract is not a contract of employment, that must mean that individual ones, they knew that those two things would be wrong. But the question is then how one construes what the exercise they in fact carried out was, whether they just looked at mutuality of obligation and stopped there, or whether, although they pinned it in the conclusion to mutuality of obligation, in fact they did an overall evaluation and a standing back, and you say that's exactly what they should have done.
Well, I certainly say the latter, my lady. In answer to a question I think my Lord Stevens asked a little while ago, for my part, it's not a necessary part of my case that one has to
But you're
judge.
not entirely letting go of the expanded first stage of RMC.
Because
I may have spoken too soon about distinguishing appointment and engagement, because the heading above 159 talks about the individual engagements. But the way I read 159 is that they found mutuality really on the Saturday afternoon.
That is correct, my lord, yes. But not for the 6 days of the engagement. And my lady is right to say that we think, my submission is conceptually, you have to look at the nature of the obligations at the first stage. If this court is against me on that, then at least you have to do it at the third. And it is quite clear that this tribunal addressed it at the first stage, rightly or wrongly, and they undoubtedly addressed it at the third stage, rightly.
In the last sentence of 159, they do say that there would be some level of mutuality during the actual engagement, and I think that means from the acceptance of the appointment, so from the Monday or Tuesday of the week, because it says, namely, for the referee to officiate as contemplated, unless he informed PGMOL that he could not. So the degree, some level of mutuality predates the actual match.
Yes, they make both points, my lord. They say that once you arrive at the ground,
there is that, yes, and then you're bound, aren't you? You've got to carry out your duty then as referee. But before that, there is still, quote, some level of mutuality, is what they're saying. But it's insufficient.
Right.
Sorry.
Yes, sorry.
It's insufficient, is their conclusion.
You couldn't just not turn up because you'd silently changed your mind without telling.
You had to tell PGMOL, but you could decide for any reason not to do it as a referee.
And you could tell them at any stage.
And you could tell them at any stage.
Before the minute before the match started.
In practice, my lord, yes.
And the minute after the match started?
Then it's more difficult.
And why is that?
Because the match has started.
So?
Well, the referee's there.
Well, the referee is there, the game has started, absent injury. The understanding and the expectation is that he will continue from minute 2 to minute 90.
If the referee's turned up, presumably he hasn't had his principal employer requiring him to be elsewhere, so it's perhaps an unrealistic thing, short of injury, for him to pull out.
Well, there have been examples of a referee team being pulled when they'd arrive at the ground because of integrity reasons. But they are rare examples, and they're not actually the subject of any findings of fact in the first tier.
I mean, as a matter of common sense, that must be right.
Yeah.
I mean, if it's found that the referee, after he arrives, it's found that he's taken a bribe as regards the match, it must be right that he can be taken off. But
Yeah, and
So whatever the nature of the
yes,
contract.
but I thought there was a finding as to the contractual obligation from the moment he arrived. At least I assumed it, I'm afraid. I didn't think I know it. I haven't read it. I mean, did the FTT actually say whether that was the case?
they do say that, my lord, and
Was it an actual contractual written term, or was it just a necessary assumption that the referee, once he's there and started the match, he's got to go on with it?
my lord, yes, there's no
contractual term. There's
Well,
no
there's no written term to that.
No written term. Yeah.
And can I just see if I can immediately find, if not somebody behind me can find, where the first tier conclude that that once you were at the match, you were expected to go through with the refereeing. The way it's expressed in 161 is freedom to withdraw before he'd arrived at the ground, but that harks back to an earlier finding that they've made to that effect, which I can't immediately remember where it is, but we'll find it. But the answer is yes, there is a specific reference.
Well, that is, yes. Mm-hmm.
I'll find that reference board, I'll cover it. What did the upper tribunal say about this? Key documents, page 117, main bundle, page 166. Paragraphs to note, paragraphs 32 through to 35, 33 through to 35, they were alive to the nature of an appeal to the upper tribunal being on point of law only. So absent perversity, it had to be an error of legal principle. What Mr. Norbat said in the upper tribunal is recorded at paragraph 36. So he submitted that mutuality of obligation is relevant only to the questions of whether there is a contract at all, and if there is a contract, whether it contains an obligation to provide services personally and obligations which are in some way work-related. So that was the contention then. Those contentions were tested in light of the authorities from paragraph 37 onwards, so they discussed the relevant case law. Paragraph 49, they rejected Mullen and Friend's contention that mutuality of obligation is irrelevant to the categorization of the contract beyond merely requiring that the services be performed personally, so that was rejected. And then they address from paragraph 50 onwards the content of the mutual obligations. There's a summary there of the relevant authorities. And then their conclusions are at paragraph 67 through to 70. 68 relates to the obligations on the putative employee. 69 relates to the obligations on the putative employer.
Sorry, where did you say their conclusions?
Beginning at paragraph 67.
67, thank you.
Drawing propositions from the case law.
I see, thank you.
So it's those paragraphs 68, 69, 70.
Yes.
They then address mutuality in the context of the umbrella contract, so we're not concerned with that, that's at 71. And then mutuality in relation to the individual contracts begins at paragraph 97, main bundle 191. And in paragraph 101, they adopt the approach that the notion of mutuality of obligation is the same when one is testing the individual engagement as it is in relation to the umbrella engagement. So that's 101. And then from 110 through to 120, they address and reject the contentions of the commissioners as to how and why it was said the first tier had erred in law. And they conclude that the first tier made no relevant error of legal principle, as would justify overturning the first tier's decision. So the case that was put to the upper tribunal is different to the case now put by the commissioners. What the upper tribunal is to reject that case. And in doing so, they find no relevant error of principle by the first tier. So what then did the Court of Appeal say? That's the key document beginning at page 87, main bundle, page 136. Court was alive to beginning with ready-mix concrete, that's paragraph 3. They identify paragraph 5, the relevant questions on the appeal. They then summarise from 10 onwards the facts that were found by the first tier, so that runs 10 through to 43. 44 sets the legal statutory context. 48, main bundle, page 145, reflects the different types of contract, so single or overarching and single. And then the court addresses in turn McMeechan, paragraph 50, Clark and Oxfordshire Health Authority, that's paragraph 58, Carmichael, paragraph 60, and Prater, paragraph 65.
These paragraphs are all summaries of those decisions.
They are. There's no comment. There's no editorial comment.
No editorial. Correct.
These are recitals, in effect, of what was decided.
Yeah.
70 sets out the first tier's legal reasoning, and that continues through to 91. 93 sets out the upper tribunal's reasoning, and then the discussion begins at 118. So Her Ladyship finds a number of principles from the authorities that they were addressed upon. 118 Roman 1, the question whether a single engagement gives rise to a contract of employment is not resolved by a decision that the overarching contract does not. It's true. No one said otherwise. 2, in particular, the fact that there's no obligation under the overarching contract to offer or to do work, if offered, does not decide that the single engagement cannot be a contract of employment. That's also true.
But you can often have a sort of framework contract that sets out the basis on which you will work if a contract under that framework is made.
Yes.
And in that case, the overall contract is not one of employment, but the terms, as it were, would govern individual contracts.
Yes. McMeechan is an example of that in effect, because the conditions in the overarching contract were imported into the individual contract. Mm-hmm. But Romans 1 and 2 are both true, but neither PGMOL nor the first tier said to the contrary. And then 3, a single engagement can give rise to a contract of employment if work which has in fact been offered is in fact done for payment. Well, if can means may do, depending on the nature and extent of the obligations, then we would have no problem with that. If it means it will be a contract of employment by virtue of these facts alone, and we say that's not right.
Well, nobody's ever suggested that, have they?
Well,
the mere fact that work is done for payment, nobody's claiming that's automatically a contract of employment.
Well, at various points in this litigation, the commissioners have suggested that. Yes.
Well, they've suggested that that will be enough for mutuality of obligation, but not then to make the jump that it's actually a contract of employment.
Now, 119 goes on to say these authorities do not support any suggestion the criterion of mutuality is the sole qualifying test. Well, that's true, but we didn't say otherwise. On the contrary, these authorities and the other authorities which suggest that the court has to look at all the circumstances in the round. Well, broadly true, but again, we didn't say otherwise. And then 120, no appeal against the first tier's conclusion that the umbrella contract wasn't a contract of employment. That's true. 121, the first tier recognised correctly the question whether the individual contracts or contract of employment was legally distinct from the question whether the overarching contract was a contract of employment. Correct. It held correctly the terms could be relevant. Windle. Correct. The terms could not be decisive, of course, but the FTT did not say they could be. All true. And then in 122, first the FTT's two main reasons for deciding there was no contract of employment was lack of mutuality of obligation. It considered that the fact that either side could pull out of the engagement before a game without any breach of contract or other sanction negated the necessary mutuality of obligation. Well, with respect, that's not what the first tier said. And then reading on, in my judgment, the first tier erred in law in deciding the ability of either side to pull out before a game negated the necessary mutuality.
Yes, this was foreshadowed in paragraph 68, which we saw earlier, where the court referred to Byrne Brothers and Stevenson. A distinct legal issue in this appeal was whether the ability to pull out negated.
Correct, my lord. And that, we say, is a misstatement.
You say that's a misunderstanding of what the first tier tribunal was doing.
Wrong on the authorities, but more importantly, not what the first tier said. It ascribes to the first tier an error that it didn't make. And then the fifth sentence in that paragraph, the correct analysis is that if there is a contract, the fact that its terms permit either side to terminate the contract before it is performed without breaching it is immaterial. And we say that, with respect, is wrong in law. It's relevant, it's material, it's not determinative. And the last sentence, the contract subsists with its mutual obligation unless and until terminated by one side or the other. And then the Court of Appeal criticises the upper tribunal in 123 for its complicated analysis, perhaps led in that direction by the parties' elaborate submissions. A little harsh.
Just pausing at 122. All you have to do is establish the points you just made. Is that right? You don't have to go on to show that the upper tribunal was wrong.
My lord, yes, because if the upper tribunal, if there was no error of law by the first tier, there was no basis on which either the upper tribunal or the Court of Appeal could interfere, and here it was the Court of Appeal interfering on mutuality. So I don't actually need to justify what the upper tribunal said, but if one does read on, the Court of Appeal ascribes to the upper tribunal errors it didn't make.
Yes, your objection to the last two sentences of paragraph 122 is that the ability to terminate before performed may be immaterial as to whether there is a contract, but it isn't immaterial as to whether it's a contract of employment.
My lord, yes. And that harks back to paragraph 68 and the reference to Byrne Brothers.
Yeah.
So as my Lord Stevens puts me, I only need to be right about there being no error by the first tier, but if need be, I go on to say the Court of Appeal were wrong to ascribe to the upper tribunal the errors it did.
It might be out of an excess of caution appropriate to explain why. Right.
In 124, the Court of Appeals say the upper tribunal was wrong to conclude that payment for work, if done, could not give rise to the relevant mutuality. But that's not what the upper tribunal said. Equally in 124, the Court of Appeal ascribes to the upper tribunal a failure to recognise that the ability to terminate the contract negated mutuality. And in particular, the last couple of sentences of 124, the fact that the individual contracts lasted longer than the match, that is from the Monday morning until the submission of the match report, is irrelevant. Well, we say again that's not right with respect.
And there's almost nothing that you would say is irrelevant, given the difficulty of identifying these contracts.
Yes,
Well, you don't need to.
I'm wary of
It's a
saying
comment
everything
rather
is
than a
relevant, my
question.
lady, but certainly one has to weigh all factors that the fact-finding tribunal at first instance regards as relevant.
There is a question of some importance, that even if the Court of Appeal were wrong to characterise the FTT's conclusion as saying that ability to pull out negated mutuality of obligation, but on your case there's still quite an important question about whether mutuality of obligation is quite a sharp question, or whether it's some sort of matter of degree that gets in there in the balance.
Well, I entirely accept and recognise this court can decide that mutuality, I put it in these terms, is a binary question. Either you have the right sort of obligation or you don't, but that then the nature and extent of those obligations is weighed at the third limb or third stage. Now, the court has my primary submission that that's too dogmatic, perhaps. But if I'm wrong about that, then there is still no relevant error of law made by this tribunal in this case.
I didn't think that the Athol House case, page 832, paragraph 76, was saying that mutuality wasn't binary. It's certainly saying that control isn't binary, but perhaps I misunderstood it.
Which page?
Page 832,
832.
paragraph 76.
Well, the case advanced to my lord in Athol House was mutuality and control are in effect yes, no. And if you answer both of them yes, you cannot consider them again at the third stage of ready-mix concrete. And my lord, Lord Richards, said, well, that's overstated because you've got to weigh, in effect, all and any terms of the contract. And my lord puts it, what is said is that no account shall be taken of the strength or weakness of the finding of control. I would say my lord would be equally right had he said control and mutuality.
But he didn't.
Didn't perhaps, but should have. the point that my Lord makes earlier in the paragraph is they're not binary, in neither test is binary in the way that the commissioners were advancing in that case.
Well, I'm sorry, I think in the first paragraph, first sentence, it's simply stating the submission. It's then saying the submission is even on HMRC's case overstated,
Yeah.
and then it goes, as it were, contrary to what HMRC says in relation to control. That's as coming to it again, I read that paragraph.
I'm not going to tell your Lordship what your Lordship must have meant.
No, His Lordship cannot tell us.
No,
what he must have
no.
meant.
The way it's put, just in case it helps, by Mr. Justice Buckley in the Montgomery case at paragraph 23, it's page 449, is that one should look at the nature and extent of mutuality.
This passage in 76 does highlight the point that I was querying. What you're weighing them against each other, but you must be comparing them to some other thing against which you're comparing them, which is, I think we agreed, the spectrum between clear contracts of employment and clear not contracts of employment.
My lady, yes, and my Lord comes back to this at paragraph 113 in Athol House, which is the nature of the exercise at the third stage, and whether there was some kind of presumption by then that you had a contract of employment. And the answer is no. What my Lord apparently blesses is the Augustine and E-Connect Cars case, where the judge had said the obligation of the tribunal is to paint a picture from an accumulation of detail. An informed, considered, qualitative appreciation of the whole may be gained by standing back from the picture. Of course, that is what this tribunal did in paragraph 174.
Could you give me the page number of 113?
It is 841, my Lord.
Thank you.
So that's what happened below on mutuality. My fifth of my 6 headings is control. As I indicated this morning, there is no relevant dispute between the parties that we can discern as to the relevant principles. We've set them out in our written case, paragraphs 74 to 82. That's key document pages 42 to 44. So we are looking for a sufficient right of control in the performance of the relevant services. It's a right, not the practical ability. It doesn't matter whether the right is exercised as long as it exists. And as Mr. Justice McKenna identified in ready-mix concrete, it may be helpful to ask control over what, where, and when work is done. But in the modern world, that's not often terribly useful because they are often dictated by the nature of the engagement. So the barrister engaged to appear in a particular case or an actor engaged to play a particular role. The authorities make clear that a right of control over how work is done is more relevant. But again, in the modern world of work, even that is a waning factor, because what may be required is often so specialised that there's no meaningful right of control over how it is done. But the case law rightly recognises that the absence of such control does not mean that there isn't a right of control sufficient to be a contract of employment.
Can you test it in a negative way, that suppose PGMOL said to the referee, we want you to go and referee this match, but we don't want you to apply the offside rule during this match, or we don't want any extra time after 90 minutes if they're tired, just toss a coin. I mean, presumably the referee would not be able to accede to that.
No, he would be obliged to apply the laws of the game, and PGML would have no right to require otherwise.
The unilateral alteration, amendment of the contract would be that he applies the rules of the game, and they would be saying, don't abide by that contractual term.
So the question ultimately is whether there is a right of control to the extent in a given case that there is scope for it. That's the language of the judge in Ready Mixed Concrete at 515 letter G, bundle page 284. So here it is on the authorities a question of degree, which is why you see reference to a sufficient right of control, or sometimes you see a reference to the ultimate authority. But again, in a degree sufficient to make one, in the old language, the servant of a master. Now, the relevant facts found by the first tier tribunal we've identified in our written case, paragraph 83.
But before doing that, I'm sorry for interrupting. Do you agree with all the propositions of paragraph 47 and 48, page 72 and 73 of the core bundle, which are the respondents' submissions about the concept of control? Is there anything there that is contentious? Don't take up the time.
My Lord, no, the only sentence that we have a minor quibble with is the last sentence of 48A. An exercise of implication by necessity in order to give business efficacy to the contract does not fall to be undertaken. Now, if that's a proposition that it never falls to be undertaken, we think it goes too far. If it does not fall to be undertaken here, we accept it. And perhaps just to emphasise, at 48 paragraph F, page 73, the monitoring, assessment and rating of an individual's performance may be, well, I underline may, and mark in the margin, that's a question of weight. And as we shall see, that is a factor that the first tier weighed and found wanting.
Sorry, where was that reference again?
Subparagraph F of paragraph 48 of Malone Friends'
Thank
written
you.
case,
Yes,
page
yes.
73.
Yes.
Certainly an important factor these days, because there are all sorts of ways of monitoring what people are doing electronically. You could see, whether they're lazing around, and then discipline them if they are, because it's a very potent form of control, potentially.
It's now possible to work out whether someone's mouse is moving on a
That sort of thing.
desktop computer. And people rig the system to move the mouse around whilst they go to something else. But that may be a mechanism of control. Yes, we accept that.
I'll have to wiggle my mouse in
But to anticipate a submission I'm going to make, whether that is good enough in a given case is an
That's for the
exercise.
tribunal, taken into account.
The Lord has it. Now, looking at what the first tier decided, to note the submissions made by my learned friend, paragraph 121, page 181 of the key documents bundle. Page 230 of the main bundle. Mr. Norbat submitted there was a sufficient degree of control. Practical realities of the relevant industry had to be taken into account. All was needed was a sufficient framework of control. The level of control exercised during matches was the same as for the select group who were accepted as being employed. There's a comparison with select group employees. There was continual monitoring and assessment. And then 3 lines down, once the referee had indicated his availability on a particular date, he had no ability to choose which match to officiate in. And then PGML also had the ultimate right to sanction referees by suspending them from officiating. Well, that's not quite right. You could be stopped from officiating on a PGMOL list,
But you need to get the FA to withdraw the registration.
Yes.
For him to stop altogether.
yes, a referee could say, well, I'm no longer active on the PGMOL list, I will go and referee Sunday morning football, or indeed lower league football.
Yeah, but the only way you can get these particular gigs is by being offered the work by the association, is that right? In these leagues, or not? Are there other referees operating in the
In these particular
league or whatever?
in these particular leagues, so leagues 1 and 2, that is governed by PGMOL.
Yes, you'd have to go to levels 3 to 9, I think, to escape from PGMOL.
It would actually be refereeing level 2 downwards,
Or 2 downwards.
referee level 2 downwards, but English football pyramid level 5 downwards.
5 downwards.
So then whatever is the National League now. So that was the case for the commissioners. And then the first tier addressed the relevant legal principles, paragraph 163 onwards. So it is not said that they misunderstood the legal principles, so their summary in 163 is accepted to be accurate and right. Then 164 records what Mr. Morm had to say about the nature of the rights that PGMOL had. And then their conclusions are 165 down to 169. 165 recognises that some of the terms of the overarching contract are relevant to the individual contracts. No difficulty with that. 166 is an exercise in addressing and weighing the significance of the assessment and coaching processes. They are found to be advisory and supportive, but not an indicator of control. (167), the referees had some freedom of choice as to where they might be asked to referee, because they could express geographical preferences. They could refuse a particular appointment or back out once accepted. And then this is the first tier's evaluation. This was not the sort of arrangement under which PGMOL could direct the referees about where to go or when to go there, or indeed what task to perform when they got there. So they couldn't dictate whether they were referee, fourth official, or linesman. In each case, the referees needed to agree to take on a particular task at a specified location, date, and time. So they had to travel to the location. That was determined by the nature of the task they'd agreed to take on. That's all fine. And then Mr. Morm had made a submission comparing the referees to clergy. And the case that was cited, though it's not mentioned in the decision, was a case called Sharp and Worcester in the Court of Appeal, about the inability of a bishop to direct clergy how to behave and what to do. And that analogy was not accepted by the first tier tribunal, first sentence of 168. but rightly the first tier said it is relevant to consider the nature of the role, engaging the existence of a sufficient right of control. Well, there's no difficulty with that. And then they say the referee is undoubtedly the person in charge on match day. He has full authority and his decisions are final. Well, that was based on the findings of fact that they had made at paragraphs 35 through to 37.
Well, that's the point of having a referee, isn't it?
But he's in charge both during the game but also on match day. So it's important to note in these paragraphs when the first tier is talking about the match and when they're talking about the match day. Because the referee is the one who is responsible, for example, to the police for security matters, for the state of the pitch, all of those aspects that might arise on match day, he is in charge. And the fact that the first tier were alive to that distinction between the match and the match day can be seen looking at paragraphs 103 sub 5 and 105, which draw exactly that distinction. 103 sub 5 and 105.
Thank you.
So each of the referees had their own match day routine about whether they went the night before or on the day, how they organised with other officials, precise time of arrival at the ground. It is the referee who is in charge on match day. So the first tier are alive to that distinction. 168, third sentence, fourth officials answer to and work with the referee, whoever that referee is. Fourth sentence, the code of practice recognises the FA alone will deal with breaches of its referee regulations, so it's the regulator. And the fifth sentence, in reality, it's hard to see how PGML could retain even a theoretical right to step in while a referee is performing an engagement at a match. However badly Mr. Rye or anyone else from PGML who might be watching thinks that the referee is doing. And then at most they could offer advice at the time and take action after the engagement has ended. And they then go on to identify the constraints on the ability to deal with a referee who has performed poorly. So they are there identifying the factors that they have found as a matter of fact, including the role that the FA plays in disciplining referees as its regulator. And they then conclude, 169, overall, well, this is their evaluation of all of the findings of fact that they've made. Overall, we're not persuaded that PGMO had a sufficient degree of control during and in respect of the individual engagements to satisfy the test of an employment relationship. They go on to recognise that there is a level of control outside match appointments because of the umbrella contract, and some of those obligations applied to matches, but there's no mechanism enabling PGMOL to exercise the correlative rights. And then in reality, the only sanction that PGMOL could impose was not to offer further match appointments and to suspend or remove the referee from the national group lists.
Are we to interpret individual engagements and match appointments in 169 as synonyms? I think probably we are.
You are, and the contrast is with the reference to match where it's clear that it's during the 90 minutes of the match.
Yes.
So what the FTT did was to evaluate the facts it had found against the background of the principles that it had correctly identified, and it formed a view as to the sufficiency of the degree of control. And that was a perfectly reasonable conclusion for the first two to have arrived at. Had this court heard the evidence, this court may or may not have formed the same view. In with respect, that's neither here nor there. So what did the upper tribunal say? That's key documents, page 117. Main bundle, page 166. Important points to note. Paragraph 14, key documents 119, identifies the revenue's grounds of appeal. 14.2, top of page 120, the contention is the first tier erred in law and or took into account irrelevant considerations, failed to take into account relevant considerations and or reached a perverse conclusion on control. That's an all-encompassing Edwards and Bairstow type perversity challenge.
Well, it's not attacking the facts.
No.
It's not really Edwards and Bairstow. It's a attack on the rationality of the evaluative judgment.
It's at its best, it's saying that having found facts A, B, and C, the first tier have evaluated those facts in a perverse way. Because anything short of that is not an error of law. And that's made clear at paragraphs 33 through to 35, where the upper tribunal reminds itself of the limits on the appeal and thus the ambit of an Edwards and Bairstow style challenge. And then the upper tribunal comes to address control at paragraph 121, page 146 of the key documents bundle. Page 195 of the main bundle. It begins by identifying what it was that the first tier had decided. So that's 121 and 122. And then the revenue's arguments are summarised at 124. The revenue's principal complaint is that whilst the FTT got the legal test right, it nevertheless erred in law in equating the right of control as the right to step in during the performance of the referee's duties under the contract. And then that is said to continue elsewhere in the decision of the FTT, paragraph 125. The allegation is the FTT wrongly focused on the match itself and arrived at a perverse conclusion, which is paragraph 126. This was an Edwards and Bairstow perversity challenge. And then 127, in addition, the FTT failed to take into account the elements of control set out in the pre-season documentation. The allegation is that they failed to take it into account. And of course, we know that that's not right. We know that the first tier were alive to the terms of the umbrella contract and addressed them in the context of control for the purposes of the individual engagements. So then there's some short submissions from PGMOL in 128, and then the discussion begins at 129. And they deal immediately with what might be thought to be an obvious point, that they don't think the FTT erred in dismissing the assessment and coaching systems as irrelevant, since it was open to the FTT reasonably to conclude that those systems consisted at most of advice. So the challenge to the weight was rejected out of hand. Then in 130, they say there's more force in the other arguments. We consider there to be 4 relevant questions. So first, did the FTT correctly apply the test of whether PGML had the right to step in and give instructions to referees. Second, was the FTT correct to rely on PGMOL's inability to impose any sanction for breach until after the individual contract had ended? Third, did the FTT err in the weight which it gave to the PGMOL's rights of control? Just pausing there, that's an allegation about a misallocation of weight. And fourth, was the FTT's conclusion that PGML could not impose any sanction for breach during an individual contract one reasonably open to it? And again, that's an Edwards and Bairstow style perversity challenge. And then 131, the upper tribunal makes the point by reference to White and Troutbeck that it is relevant to see whether there's a right to step in. Do we agree? In 132, the upper tribunal make the point that an inability to step in does not mean that there's no right to step in. Do we agree with that?
That's a very fine distinction.
Yes.
My lady, it is, but it's a distinction that's drawn on the authorities.
You mean an inability in practice?
Yes. That's what White and Troutbeck is about.
In practical terms.
In White and Troutbeck, it was an estate in the UK managed for some external owners who lived in Africa. And they had no ability in practice to step in, but it was said they had the contractual right to do so, and that was sufficient.
I can see it in that context. Makes sense. If it's a surgeon, it seems rather, for example, say that you have some sort of right to tell the surgeon how to conduct the operation, it seems a bit unrealistic.
And the more specialised the nature of the service provided, the harder it is in the modern world to think that control is a particularly useful guide.
That sort of control, yeah.
So
necessarily thought this through, but surely there is a right to step in if a referee is committing fraud and it's patently obvious that he's doing so, or indeed there's a right to step in if a surgeon is mutilating a patient on the operating table.
in the surgeon's example, the way it's put in the authorities is that you may or may not have a contractual right to step in if he is displaying bad practice. The point that is made is that your practical inability to do so doesn't mean that you don't have a right to do so, and it's the right that matters. Perhaps the neater example is the broadcaster in a live environment. You typically don't have a practical ability to stop him or her saying something that they shouldn't. But you often have a contractual right to do so, and the authorities say the latter is good enough. All other matters being equal. So it is often a fine distinction, but at the moment the authorities draw that distinction between a practical inability and a right. So we have no difficulty with the proposition in the Upper Tribunal's 132 that an inability to step in doesn't mean you can't have a right to step in. That's fine. We agree with that. And then in 134, the Upper Tribunal say what you're looking for is some sufficient framework of control, and that might be expressed in terms of ultimate authority over the man in the performance of his work. Well, again, we have no difficulty with that. We don't read that as a different test. And then in 135, the Upper Tribunal reiterates that a practical limitation on the ability to interfere does not itself mean there's no sufficient control. Well, we agree with that. And then in 136, the Upper Tribunal rightly note that you're looking for a sufficient right of control which subsists for as long as the contract subsists. We say that's right, but the first tier didn't conclude otherwise. Then in 137, the Upper Tribunal say the critical question in this case is whether the absence of an ability to step in to regulate the referee's performance of his core obligation means that there is not sufficient control. Well, with respect to the upper tribunal, that's not what the first tier said. First tier does not reason that there is insufficient control because there is a practical inability to step in. So that is to ascribe to the first tier an error that it didn't make. Now in 138, the upper tribunal answers its own question, perfectly correctly, that there is a distinction drawn between the contractual right to step in and the practical ability to step in. Where the upper tribunal goes wrong in our submission is at 139. So they say, in answer to the first two questions we have posed in paragraph 130 above, we consider the FTT in relying at 168 and 169 on PGMOL's inability to step in while a referee is performing an engagement at a match, on PGMOL's lack of ability to exercise the correlative rights during an engagement, and on the fact PGMOL could only impose sanctions after the end of the engagement, took into account irrelevant considerations. Well, with respect, that is to misread what the first tier actually said in 168 and 169. The first tier were alive to the difference between a right to step in and an inability to do so. And the first tier were not saying that those were irrelevant considerations. They were expressly saying that those were considerations that they had examined and weighed as part of their overall conclusion that there was an insufficiency of control.
But the upper tribunal seems to be saying they were wrong to take those into account, that they were irrelevant considerations. Isn't that what they're...
Yes, the upper tribunal say they're irrelevant.
Yes. You say that's wrong.
I say that's wrong. They are both relevant considerations and ones that the first tier actually took into account. So they are here ascribing to the first tier errors it didn't make. And they then go on at 140. Separately, we consider the first tier also erred in the final two sentences of 169 in concluding that if an issue emerged between the commencement of the contract and match day itself, there was no control during an engagement.
So on 139, you're saying that the FTT did not take those considerations into account. Is that what you're saying?
No,
No, you're saying they did, but
they're relevant.
But
I would say that they are A, relevant, and B, they were in fact taken into account.
I see.
but the upper tribunal was saying they were irrelevant.
Yes, I see.
And you say that's an error of law.
Yes.
Yes, they are. Right, thank you. I'm sorry, I interrupted you.
I think the problem is that the words in second line, FTT and relying, then there's a lot of text, and then the very end took into account irrelevant considerations. Yes, 140.
140, it's a contention that the first tier also erred in the final two sentences of 169, and that was the point, no control during an engagement, because you couldn't do anything other than terminate the contract. And they say the sanction of terminated contract is one that can only be exercised by definition during the continuance of the contract, even though the effect of the sanction is to bring the contract to an end. Well, in a sense, that's all true. But they say in answer to the fourth question we posed above, therefore, we conclude that it was not open to the FTT to conclude that PGML was unable to impose, during the period of an individual contract, any sanction for breach by a referee. Again, that's not what the first tier said. One compares the way that this is phrased by the upper tribunal in paragraph 140 with what the first tier actually said in paragraph 169. One can see that these are arguments that pass like ships in the night. One is not addressing the other. that's the upper tribunal answering their fourth question. And then in 141, they go back and answer their third question. The conclusion the FTT erred in the respects we have identified does not necessarily mean that PGML did exercise sufficient control. It does mean, however, in answer to the third question we have posed in paragraph 130 above, that the FTT erred in the weight which it gave to PGMOL's rights of control. Well, that's an allegation of misweighing. And in effect, the upper tribunal is saying, well, because you, the FTT, made the errors we think you've made, we think you must have given the wrong weight to various factors. So it's parasitic on their earlier conclusion, but it's also a contention that the first tier have ascribed the wrong weight to particular elements. And that's not open to the upper tribunal. The weighing exercise, the evaluation exercise, is one for the first tier. So our core complaint about the upper tribunal is they ascribed to the first tier errors that it didn't make, and the upper tribunal itself errs in law in the way that it addresses the factors that the first tier relied upon in forming its view about control. So what did the Court of Appeal say? That's key document page 87. Main bundle document 136. But we can pick it up at paragraph 126. There's key documents page 114. So second sentence, the FTT directs itself correctly in paragraph 16 and 163. That's the Court of Appeal saying it got the legal principles right. However, in paragraph 168, I consider the FTT misdirected itself by considering whether PGML had an even theoretical right to step in while the referee was actually officiating. It asked itself the wrong question. And then 4 lines down, the FTT seems to have treated this as a decisive consideration and not to have asked whether the relationship between PGMOL and the national grid referees, including the terms of the overarching contract, amounted to a sufficient framework of control. Well, with respect to the ladyship, that's just not right. The first tier was alive to the terms of the overarching contract. It addressed them, and it did not regard the lack of a right to step in as being a decisive consideration or the decisive consideration. And then she goes on, I further consider the FTT erred in law in concluding that the coaching and assessment systems could not be relevant to the question of control. Well, the FTT did not say they could not be relevant. It was regarded as relevant and weighed and found to be insufficient. The FTT came to the conclusion they were advisory only. And then she goes on, Malay goes on, the FTT considered the assessment system in the context of individual match appointments, but that was not the only relevant question, as the terms of the overarching contract were also potentially relevant to question whether there was a sufficient framework of control as regards individual appointments. Well, the FTT was alive to that. And she goes on 4 lines down. The point is the assessment system gave PGML a significant lever with which to influence the performance by national group referees of their individual engagements and was thus plainly capable of being relevant to the question of control. Well, that would be a good answer had they not addressed it at all, but they did. And she says, I also consider the coaching system is potentially relevant to the question of control. These are all observations that, with respect, were just not open to the Court of Appeal. And then paragraphs 128 onwards the court summarises what the upper tribunal had done, and Her Ladyship says at 130, with 2 qualifications, I consider the upper tribunal's analysis was correct. The first qualification is the authorities do not require that an employer's directions be enforceable in the sense that there's an effective sanction. And Her Ladyship goes on to say, I do not consider there is any such requirement. She says for 2 reasons. First, control may be exercised by positive as well as negative means. Second, the upper tribunal's formulation assumes wrongly, in my judgment, that a contractual obligation is only enforceable if the employer has an effective sanction in relation to it. A contractual obligation is by its very nature enforceable if necessary by legal action. Well, again, we would say with respect, well, that's true, but again, that's not the point that the first tier were making, nor indeed is it a point that the upper tribunal made. And then she says at 131, the second qualification is not an error of law to give insufficient weight to a relevant matter. We say correctly. Questions of weight are for the first instance decision maker. Yes. In my judgment, the better reading of the FTT's decision may be not so much that it did not give sufficient weight to the elements of control conferred by the overarching contract, but it did give decisive weight to irrelevant considerations, that is, PGMOL's inability to step in during a match. Well, that is either an impermissible breach of my lady's own injunction, which is to interfere in matters of weight, or she is there erring in law by misascribing to the first tier an error that it didn't actually make.
But something has to be given decisive weight, otherwise you can never arrive at a decision.
I think what you must mean is that giving it decisive weight so that it precluded taking account of other things, but you say that that's not an error they made.
Correct.
Yes, it's giving any weight to an irrelevant consideration would be an error, but whether it would vitiate a decision might depend on how material it was to the decision.
Well, that must be right. If one has factors A to E, the first tier tribunal is perfectly entitled to say, well, we weigh A, B, and C more heavily than D and E. But absent some other error, that's not an error of law. So the Court of Appeal, in effect, compound the errors of the upper tribunal by agreeing and enforcing the upper tribunal's conclusion. But our core complaint about the Court of Appeals, paragraphs 128 through to 132, is that Her Ladyship ascribes to the first tier errors that, on careful reading of the first tier, it didn't in fact make. And of course, standing back for a moment, this in a sense shouldn't have been a surprise for the first tier to conclude that a body of referees who are engaged so as to be independent of the competitions where they are to work, conclusion that they are not subject to the outside influence of PGMOL shouldn't have been a surprising conclusion. It's the very purpose of this list of referees.
Well, they're independent of either of the teams, but are they supposed to be independent of PGMOL? What does that mean?
They are meant, my lady, to be independent in the sense of everybody, so that the competitions can be assured that there is no outside influence that may unfairly or unlawfully influence the outcome of a football match. And if it may help, the passages dealing with the need for referees to be independent, that being the rationale for PGMOL in the first place, are paragraphs 42.
The requirement, the duty to be independent, though, can't be incompatible with being an employee. Can't say that just because somebody's an employee, they couldn't be an employee if they have a duty in their work to exercise completely independent judgment.
That was not my proposition.
No.
My proposition was that having weighed the evidence and the factors in this case to arrive at a conclusion that there wasn't a sufficient degree of control is consistent with the findings that have been made elsewhere, but relevantly not an exercise that the upper tribunal or the Court of Appeal could interfere with, absent some clear error of law, of which there was none. And it's paragraphs 42 and 125 in the first tier. I'm in danger of going into extra time, but that takes me to my last heading, 6th of the 6th, the disposal of this appeal. The Commissioner's case is that the Court of Appeal decision was right, and this case should be remitted to the first tier tribunal. We say no, that is not necessary here, because there is no relevant error of law by the first tier as regards mutuality or as regards control. And if I am right about either of those, you would allow the appeal. It is only if I'm wrong about both of them would the Court of Appeal's order stand and this matter would be remitted.
So suppose we concluded there was no error in their decision on control, but there was on mutuality. You say you still win, do you? Even if the approach was one of weighing everything together in the balance that they followed?
Yes.
And why is that? Because if they suppose, for the sake of argument, that they were wrong to treat mutuality as something that gets factored in the overall assessment.
On the authorities thus far, up to and including my lord in Athol House, mutuality and control are described as preconditions, the absence of either of which would lead to the conclusion that there's no contract of. Now, if that's not right, then I say that those factors still have to be weighed at the third stage.
Yes, that's what I'm considering.
And if one of them is found to be wanting, i.e. not present at the third stage, then I would say that precludes a conclusion that there's a contract of employment. Because again, if one stands back and thinks of first tier tribunals and employment tribunals going forward, once this court has ruled, they eventually need to decide whether Mr. or Mrs. X is an employee or not. So they need some framework of principle.
So basically, if there was insufficient control, then then you should succeed, because that's a good enough reason by itself that someone's not an employee.
My lord, yes, because if that is not right, how does an employment tribunal hearing a case in the week after your lordship's and my lady has ruled actually go about deciding whether a particular person is an employee or not?
Otherwise, you might as well just have the third stage and do away with it.
You're left then with an open-ended, multifactorial test with no principle of guidance, the practical result of which, I'm afraid, will be many more appeals, perhaps not to this court, but certainly to the EAT.
The Court of Appeal busy.
It would keep the Court of Appeal busy.
Either that, or the amount of saying you could do whatever you like, with really no real structure to it, which wouldn't be good either.
My lord, that's a recipe for medium and long-term chaos. So, my lord, unless I can help the court further, those are my submissions.
No, thank you very much, Mr. Peacock. Given the hour, I think the court will adjourn, and we will look forward to hearing you tomorrow morning.